Hi, Assalamualaikum warahmatullahi wabarakatuh. My name is Fatin Farhana binti Ahmad Yazid, number matric 272211. In this video, we are going to talk over question of assignment 2, which is part 1. Here, we are going to discuss 3 different situations. First is the number of shareholder required for a private company. Second situation is conflict of interest among directors, shareholders, and company itself. And lastly, conflict arises under pre-incorporation contracts.
Hi, my name is Dina Hani binti Ramzi, number matric 272168. Let's start with the first issue, whether Tuba Energy Sdn Berhad can have 57 shareholders. So for this situation, we are going to refer to the law under section 42(1) Company Act 2016. Under this law, it is stated that the membership of a private company like Tuba Energy Sdn Berhad shall not exceed 50 membership, as it is the maximum membership required. The suggestion to Tuba Energy Sdn Berhad is now they have two choices. Either they want to reduce the number of shareholders to 50, or they can proceed with 57 shareholders. But it is advisable for them to change the status of the company from private company to a public company, so that they can continue doing their business without any problem. In conclusion, Tuba Energy Sdn Berhad cannot have 57 shareholders as it is a private company, but they can do that if they change their status to a public company. I think that's all for me. Thank you.
Hi, my name is Anis and I will proceed with the second question, where we need to justify whether either Mr. Razi or Company X should be responsible for the secret profit made from Kelim Berhad. For your information, Mr. Razi is a director at Kelim Berhad and at the same time the sole shareholder and director of the Company X. For this, we need to look at Company X 2016 under liability, where it is clearly stated that when there arises conflict of interest between the director and the shareholder of the company, any director that violates its fiduciary obligation for his own interest must be personally responsible and not the company. Here are some of the duties stated under this law. In Section 175, in order to prevent conflict of interest, a director must avoid a situation in which he has or may have a direct or indirect interest that in conflict or may conflict with the company's interest. We may relate this question to the case of Fairview School Berhad vs India Rani Anak Perempuan Rajaratnam, as the promoter must not benefit from the firm profit without the company's permission. They must also disclose any possible conflict of interest in every transaction in the firm that may be involved. Another similar case is Per Festival vs Rick, about the director's duties toward the shareholders. A company's director are not trustee for the individual shareholder, and they must acquire their share without revealing existing negotiation for the sale of the company's undertaking. Applying the law to the present situation, Mr. Razi is the one that should be responsible because he is the offender. Toward Kelim Berhad, he had incurred secret profit from Kelim Berhad by taking advantage of his position as a director without Kelim Berhad acknowledgement and transferring it to Company X for his own interest. Kelim Berhad can get back the secret profit from Company X and also compensation from the Mr. Razi. In conclusion, Mr. Razi acts as the directors and also as shareholders must be responsibility for his fiduciary relationship. That's all from me. Thank you.
Hi, my name is Pisa Anak Laki Adam, and today I'm going to explain the third issue, that is it acceptable for a fully established organization to be bound by a pre-incorporation contract? First of all, what is a pre-incorporation contract? A pre-incorporation contract is based on Company Act 2016 under Section 65 subsection 1. Any contract made at the time when the company has not been formed has effects as a contract or transaction made with the person purporting to act for the company or as agent for it, and he is personally liable on the contracts or transaction accordingly. While under section 65 subsection 2 stated that company shall be bound by the contract as if the company has been existent at the date of the contract or transaction and had been a party to the contract. Alright, so the case that we are going to refer is Ahmad bin Saleh and Anas versus Rawang Hill Resort Sdn Bhd 1995 3 MLJ 211. So this case is about a plaintiff who entered into a pre-incorporation contract to sell a piece of land to the defendants. So the agreement mentioned all these points are: the issue arises when the defendant violates the agreement. So the court has dismissed the plaintiff to claim and allowing the defendant to counter any litigations during the agreement, even when he is absent. This is because the agreement made were approved under Section 35 Company Act 1965. So the plaintiff will bear from raising any issues they had before the trial, accepting the defendants as the legal entity in the original sales and purchase agreement. As a conclusion, a pre-incorporation contract is not binding on the organizations, as the person acting on behalf of a company is responsible for such contract or transaction unenforceable. That's all from me, thank you.
The last part in this video is conclusion. Based on the three situations, we conclude that maximum number of shareholders for a private company is 50 shareholders as required by SSM. Next, any secret profit made by someone that violated his fiduciary obligation towards the company for his own interest must be personally responsible. And last, pre-incorporation contract shall not be treated like a normal contract since it happened before the company was established. That's all from our group for part 1. Thank you.
Introduction. The company establishment procedure start from the name search until the company is registered to the register of the company. A company will have the effect of its own special establishment when compared to other business organisation. Section 31(1) of the Company Act 2016 provides that the company other than limited company by guarantee may or may not have the constitution. If a company does not have the constitution, then the company director, member of officer do not have the right or duty to carry out their duties and responsibility in accordance with this act.
I'm going to present question 2, which is the first Roman. Bank Megah Berhad is going to change its name to Bank Megah Jaya Berhad. So the issue is whether Bank Megah Berhad can change its name to Bank Megah Jaya Berhad. Next is rule. The law applicable in this situation is Section 26(1) Companies Act 2016 provide that the name is available as long as it is not identical to the name of an existing company, not same as the reserved by another company, and not identical to the name that cannot be used for registration as directed by the minister. If a company used the name of an identical to the existing company, the existing company can apply for an injunction. A case to illustrate it is the case of North Cheshire and Manchester Brewery Co. Limited versus Manchester Brewery Co. Limited, 1899 AC 144. In this case, the respondent applied for an injunction from the court to block appellant from using the name that is identical to the respondent company name. The respondent contended that if the appellant continued to use the name, it will cause confusion among the general public who deal with both company, also in terms of legal proceeding involved, and assume that both company have a connection. So House of Law have accepted the injunction to avoid the confusion among the public as the name of the both companies are similar. As is application, Bank Megah Berhad can change their name to Bank Megah Jaya Berhad as long as it's not same as the existing company and not reserved by another company. And also, the company must end with Berhad words or BHD to show that they are public company. This is supported by the above section, which is section 26(1) Companies Act 2016 that I just explained previous. To avoid from using the same name, Bank Megah Berhad can also visit the SSM website and also search the name on micro-ID system. In conclusion, Bank Megah Berhad can change its name to Bank Megah Jaya Berhad as long as it's not used by existing company and not been reserved by another company. So I think that's all from me. Thank you. I'll pass to the next presenter.
I will continue present for the question 2.2, which is Fulmak Berhad refused to repay the loan to creditor A as A is also substantial shareholder in FMB. The issue for this case are whether Fulmak Berhad has to repay the loan to creditor A, which is also a substantial shareholder in FMB according to the section 21 subsection 1 of the Companies Act 2016. The law applicable in this situation is supported by Rule Changeant ETAL 2010. When a company is registered, it gives rise to several effects. Section 21 subsection of the Companies Act 2016 provides a company should be able to carry out all the function of a body corporate and have full capacity to carry on or undertake any business or activity, including done any act that may be done or to enter to the transaction. A case to illustrate is Lee vs. Lee Farming Limited, 1961. Lee had set up a company, namely Lee's Air Farming Limited, where Lee is the sole director in the company. All shares except one are owned by him. He entered into a contract with the company to be employed as a chief and sole pilot for the company. Lee was killed when he's flying for the company. His wife made a compensation. His right depends on whether Lee is unemployed or not. The Court of Appeals ruled that Lee was not an employee because a person could not employ himself. The case was then taken to the Privy Council. The Privy Council allowed Mr. Lee claim because Lee could enter into a contract with the company and be considered an employee. Lee and his company are different entities.
Application. Fulmak Berhad FMB should repay the loan to the creditors A even though the creditors A is substantial shareholder of the FMB. In the context of contractual obligation, the principle of separate entity means that the company does not contract with itself even if the obligation is entered into the behalf of the companies by the member with whom the contract is entered. Conclusion. Fulmak Berhad FMB must be liable for the company debt even though the creditors A is the part of FMB, which is the company shareholder.
So, the issue in this case is whether company B is allowed to not have a company constitution or not. Next is rule. The law that is applicable to this situation is Section 31 Clause 1 Companies Act 2016. The company constitution is optional to any company except for a company limited by guarantee. So according to Section 31 Clause 3, if a company does not have a constitution, the company, each director and each member of the company have the rights, power, obligations and responsibilities outlined in this act. The case to illustrate this situation is Beh Chun Chuan vs. Palu Medical Center Sdn Bhd 1999. In this case, the petitioner contends that a corporation violated shareholder requirements in a way that oppresses the petitioner. Agreements not contained in the company's association processes. So according to the court, a shareholders agreement is simply a contract between members of a corporation to manage their conduct and define their rights and obligations in the course of the firm. In order for the conditions of the shareholders agreement to be enforceable on shareholders under the Companies Act, they must be included in the company's constitution. As a result, the court dismissed the claim and ruled that the petitioner's contention that shareholders agreement waived the association's discipline was untenable.
Thank you, Azira. Next, I will present about applications. In this case, it's not a state where the company B is a company limited by guarantee or not. So, company B are allowed to not have a company constitution as mentioned in Section 31(1) Company Act 2019. Each of director and members of the company has right, power, obligation and responsibility outlined in Company Act 2019 according to Section 31(3). For the conclusion, Company B is not a company limited by guarantee, so is allowed to not have a company constitution that state under Section 31(1) Company Act 2019.
Conclusion. A company will become an entity with its own characteristic once established by complying with all the procedures prescribed by the Companies Act 2016. Other than that, a company is not required to have a constitution unless the company is limited by the share. The constitution of each company must state the matter stated in Section 35(1) of Act 2016.